All right, welcome everybody. Good afternoon. My name is Josh Gadharf. This is the TMA Detroit's Small Business Restructuring Act 1 year later webinar. Thank you all for taking an hour out of your day to hear us talk. We'll get started in a couple minutes. Let me just run through our sponsors. As you see on there, the TMA Detroit would like to thank all the gold sponsors, silver sponsors, and bronze sponsors. Your help is greatly appreciated. So thank you. Just a quick shout out, next week, a week from today at 4 o'clock Eastern, the TMA Detroit Next Gen is having a Learn from the Past and Position Yourself for the Future event. It's free to members and guests, as you can see. So if you'd like, please sign up. Looks like there's going to be a great panel of folks from the Conway McKenzie firm. So please join the TMA Next Gen. You don't have to be Next Gen, from what I'm told, to join the Next Gen events. So please do that. And then finally, quick reminder of the Board of Directors for 2020 to 2021. You can see everyone on there. Can thank them all for their service. Hopefully some or all of them are on the webinar right now. So why don't we get started? Thanks again for joining. We're going to be talking about the Small Business Restructuring Act 1 year later. We have a fantastic panel today. First, we have the Honorable Daniel S. Opperman, who is the Chief Bankruptcy Judge for the United States Bankruptcy Court for the Eastern District of Michigan in Bay City, and has been a judge on the court since 2006. Judge Opperman served for 6 years on the Bankruptcy Appellate Panel for the Sixth Circuit and was the chief judge of the panel for 2 years. He graduated magna cum laude with a JD degree from Wayne State University Law School in 1981. While there, Judge Opperman was a member of the Wayne Law Review and served as note and comment editor. Next, we have Ronald Spinner, who's a principal in Miller Canfield's bankruptcy, restructuring, and insolvency practice. Ron delivers results-oriented strategies to clients with a special focus on preference defense. He is a member of the Turnaround Management Association and the Accounting Aid Society. Next, Rozanne Giunta, who is joining us from Florida, but she is a partner of the law firm Warner, Norcross & Judge, LLP, which has 8 offices throughout the state of Michigan. Commercial law and bankruptcy have comprised 95% of her law practice for over 42 years, which includes representation of debtors, creditors, and creditors committees under all bankruptcy chapters and out-of-court workouts throughout Michigan, Delaware, and New York. Rozanne was inducted as a fellow in the American College of Bankruptcy in 2011 and is a frequent lecturer for the American Bankruptcy Institute, Federal Bar Association, State Bar of Michigan, and Institute of Continuing Legal Education on debtor-creditor rights issues. The final member of our panel is Colette Gibbons, who is a practicing bankruptcy attorney at the Cleveland office of McDonald Hopkins. She has served as a Chapter 11 trustee, a receiver, and recently a Subchapter V trustee. In 2015, she worked on 2 bar committees to amend the Ohio receivership law to make it more amenable to the needs of Ohio debtors and creditors. Colette is a member of the American College of Bankruptcy. My name is Josh Gadharf. I'm a partner in the Business and Business Restructuring Services departments at McDonald Hopkins here in Detroit. My restructuring practice involves navigating debtors, lenders, and distressed debt investors through in-court or out-of-court restructuring processes. I also regularly serve as general outside counsel for non-distressed businesses. So now that you know all of us, for those of you who don't know us already, why don't we get started? I know a lot of us are thinking back to a year ago today and the changes that were going on in all of our lives in March of 2020. But we're here to talk about something that was enacted by Congress in February of 2020. That's the Small Business Restructuring Act of 2020. Let's take a few minutes quickly to recap and get a quick refresher course on the core differences between Subchapter 5 and a normal Chapter 11. So Ron, why don't you take the lead? Tell us some of the key distinctions between the SBRA and a normal Chapter 11.
Sure, absolutely. As Josh mentioned, a year ago, almost today, we gathered at Miller Canfield's Detroit headquarters and went over in detail the SBRA. We're not going to do that. We'll just hit the highlights today. And unfortunately, I can't give you the Slows barbecue that everybody keeps talking about that we served on that day. But we can have a short overview of what differences there are from regular Chapter 11 to the SBRA. And the most important, I think, for small businesses is the abolishment or the lack of the absolute priority rule. A lot of small businesses, if they want to file, mom and pop business, if they're going to file, it's great to be able to save the business, but the mom and pop want to still own the business afterwards. And that's really tough to do in the Chapter 11, unless you can either pay your unsecureds in full or you have very skilled and successful legal tricks, which may or may not work. That's all gone on the SBRA. Mom and pop can retain their interest after they reorganize. And that's a big attraction. It makes it even possible to consider. There's a lot of things to reduce creditor. Some people would say obstinacy. I would say creditor involvement, since I'm mostly a creditor's attorney. There's no ability for creditors to file competing plans. You don't have to get at least one class of creditors to approve a plan, your plan to have it crammed down. This makes it a lot easier, potentially, to confirm a plan. It's also a lot cheaper. There's no creditors committee, at least by default, unless the court feels one is necessary. There's no U.S. trustee fees. There's an expedited timetable. And all of this is supposed to, now we'll see if it works, but it's supposed to compress down the costs and the time to get the business back into play and resolve with its bankruptcy case. Big change is that they include a Subchapter V trustee, and each trustee under each chapter is different from each other. The Subchapter V trustee, I believe, kind of functions like a cross between a normal Chapter 11 trustee, a Chapter 13 trustee who kind of supervises the case, and a mediator. The reason we say mediator is because the main goal of the Subchapter V trustee is to try to get all parties to hold hands, sing kumbaya, and agree on a consensual plan, or at least all classes of creditors, if not all parties, so that you can get a consensual plan confirmed. If the trustee cannot do that, it doesn't always happen, but they can still confirm a plan non-consensually, then the Subchapter V trustee will supervise the collection and distribution of funds. So some people are, like in a Chapter 13, people are confident that there's somebody keeping an eye on how things are going. And the trustee is always there in case, God forbid, the debtor in possession is removed from that role. The trustee can step in and operate the mom and pop business or whatever the small business is to keep it going.
So Ron, real quick, how is the plan process different in Subchapter 5?
Well, in some cases, there's a model plan out there because it's like a Chapter 13. There's certain things you just have to do, which we'll talk about. You have a more formulaic idea, at least you can have a more formulaic plan. And the fact that nobody but the debtor can propose a plan keeps it much simpler. You don't have people aren't trying to extend the dates for which the debtor is the only one that can file a plan. There's no pressure on the debtor to do a plan that some particular creditor wants, because no creditor can boycott the plan that way. As long as they meet certain criteria, the plan gets confirmed. So it takes some of the pressure off. That there's other pressures that are put on in the plan, and that's kind of what it's supposed to keep it fair. Is that to confirm a plan, it's got to be fair and equitable. And for a secured creditor, nothing really has changed from Chapter 11. But for the unsecured, there's a big change in the focus. The focus in a regular Chapter 11 is getting the unsecureds paid in full or as much as possible. The focus in a Subchapter 5 plan is very much more like a Chapter 13 plan. Is what can the debtor afford? And how much good can the debtor do toward its debts? Because there's no point in getting blood from a stone after that point. It's like at least that's the theory. So to confirm a plan, it's got to be fair and equitable, term of art in the legal phrase. And that means the debtor has to be proposing, for unsecureds at least, its projected disposable income over 3 to 5 years, the life of the plan, or at least an amount of money that's equivalent to that. And if you do that, then the court is satisfied, or the law is satisfied, that the debtor's doing all that they can, and then the plan gets confirmed, even if that's something that some of the unsecured creditors might not truly appreciate, or would not ever fly in a typical Chapter 11. Now, you may or may not have ballots to try to determine whether or not everybody agrees. We'll talk about that in a little bit. And there's also this possibility of a limited discharge. It seems a little bit foreign to bankruptcy people to hear that your discharges may not discharge long-term debts, but it's really not. If you think about it, Chapter 13, in Chapter 13, people often file to keep their houses. And at the end of the Chapter 13 plan, after 5 years, they don't have the mortgage forgiven. They're not paid up in full, the house is still there and the debt is still there, but it's current and everything is back to where it's supposed to be. And then in theory, from that on, you go on, you make your plans and your house is saved. And they've imported that into the idea of a subchapter 5 to the extent a small business actually has these really long-term debts. You don't necessarily have to get rid of them all in that 5-year period, but you can at least kind of structure them in such a way that they're back on track and then they can be resumed normally afterwards. Now, if you have a non-consensual plan, you will have some minor things left over. You won't be able to get discharged from things that would normally not be considered non-dischargeable. Like if the debtor's committed fraud or willful malicious injury, that's not going to fly. There are a few other things that people need to be aware of, is that debtors still have to comply with the Bankruptcy Code provisions for Chapter 11. So you can't just run around using cash collateral. You can't just run around borrowing money, providing adequate protection without court authority. And that's stuff that's imported from Chapter 11. It's still there. And, professionals should be well aware that this is not just a Chapter 13. This is a small Chapter 11, not a large Chapter 13, and it does have business requirements that you need to meet. Although professionals still have an easier time of becoming a representative in that subchapter 5, because previously or standard Chapter 11, you have to be disinterested, which means that if the debtor didn't pay all of your fees as a professional beforehand and you're owed a few dollars, well, you're interested, you have a claim and you can't represent. So what people would normally do is have to walk away from that claim and say, all right, I'm not going to collect it, I forgive it, so that I can keep going. Now you can keep up to $10,000 of that as a claim and maybe recover something for your pre-petition services and still serve. So it's like a Chapter 11. There's a lot of stuff in common with Chapter 11, but the key difference, that absolute priority rule, the lack of creditor really ability to completely stop the thing dead in its tracks, this makes a big deal, because I've done this. As a creditors committee, as a creditors counsel, I've sometimes bought up a few claims and said, now you need to talk to me. Can't do that here. So creditors have to take a different tack.
Thanks for that. And we're going to talk about what we've seen in our practices during the last year and how this act has really been utilized over the last year. There were some additional changes since the panel Ron talked about last year with the barbecue, including the Consolidated Appropriations Act of 2021. Right, Ron? There were some changes there to 365.
Yeah, we should talk briefly about that. 365D in the Bankruptcy Code deals with non-residential leases. And to make it simple for people, that's basically it's not a house. If you think of your storefronts, your warehouses, your office places, the places the debtor has to conduct business. And typically, even if you're in default, as of the date of the petition, once the petition is filed, the trustee's got to perform under the lease. Now, there's some room to get an extension for 60 days, so you don't have to immediately perform. And by perform, that means usually pay rent. But there's a special provision added to 365D3 for subchapter 5 cases. It says, if you're suffering financial hardship from COVID specifically, you can ask for 60 days, and it kind of makes it easy for the court because it's spelled out. If it's a COVID issue and the court's convinced it's a COVID issue, you can get 60 days before you have to perform, and you can even get another 60 days on top of that. And that is a way to give the debtor some breathing room during the pandemic to get to figure out what they're going to do before they have to start shelling out cash. There's also, as you mentioned, a related provision that applies to all bankruptcy chapters, but it's so close to this one. For non-residential leases, normally you have to decide within 120 days, 4 months, what you're going to do with them. You're either going to keep them, and then you're going to have to cure them and all that, or you're going to get rid of them because they don't make any sense. They've changed that, and I first thought it was a typo because when they wrote it down, it was 120, and now it's 210. It just looked like they transposed the numbers. But now they've extended the period from 4 months to 7 months where debtors have to make a decision, which gives them, it doesn't mean you're absolved of paying rent for that time, but it means you're not automatically evicted if you decide you haven't figured out whether or not a lease makes some sense. Together, these things sort of give you some more time, and well, bankruptcy is all about breathing room. These sort of make sense, especially during a pandemic. Although, if you're a landlord, you may have different views on that.
Yeah, and based on the speed of how some of these subchapter 5s go, that 7 months could be the entirety of the case.
That's true. That's true.
All right. Well, let's move on to the debt limit, because I know that's been a moving target a little bit over the last year. Colette, you're a trustee in Ohio. The debt limit originally started at $2.7 million. Can you explain, first of all, just to recap for all of us, what that means to have a debt limit for eligibility purposes, what's calculated, and
Sure.
then talk about the movement over the last year.
Okie doke. We can talk, I think we can start here with what the recommendations were by the ABI Commission on reform of Chapter 11. That was the commission that came up with the idea of small and medium-sized bankruptcy treatment different from Chapter 11. And they, the commission had recognized the need for something different and decided that the debt limit for what they envisioned was going to be 10 million. So then I think legislatively, this matter relative to small and medium-sized businesses moved slow at first, then quick, and then all of a sudden Congress decided that the debt limit would be 2.7 million at the time that it was enacted. That didn't seem very high. That didn't seem too functional. When COVID hit, I think it was March or April of last year, Congress raised the debt limit to 7.5 million. And there's legislation pending now that will continue that. The initial 7.5 million was just for a year. And I think that there is pending legislation continuing that limit. So I think it's probably at least half of all Chapter 11s are qualifying at that debt limit. Some of us would like to see it higher. Some think it's too high. But for now, we're at 7.5 million.
And 7.5 million of what type of debt is used to calculate?
Well, if it's, and Rozanne will talk about this later, but it's unliquidated or liquidated debt and trade debt, secured debt, business debt. And if the debt is unliquidated, then that's going to be the story of one of the cases we're going to talk about a little bit later.
Okay. And Rozanne, I know you've been paying attention to legislation. I think the $7.5 million limit has a sunset provision in later this month. Do you anticipate that being extended, and what are you hearing on that front?
Yes, that's correct. The legislation that was passed during COVID had a sunset provision of March 27th, 2021. Everyone's been getting a little bit nervous about the fact that we're getting very close to that, and no legislation has been proposed to extend that. Well, late last week that changed. Senators Durbin and Grassley proposed a bipartisan bill that would extend the deadline for another year. They would extend the provisions to March of 2022. That bill is expected to pass. It's bipartisan. As I'm sure most of you know, Dick Durbin is the chairman of the Senate Judiciary Committee. Senator Grassley is the ranking member of the Senate Judiciary Committee. So there does not appear to be any reason why that legislation won't pass and won't be through the court and signed by the president before the deadline expires. But that bill not only extends that deadline, the increased debt limitation, but it also amends or extends some other provisions that aren't as relevant here with respect to Chapter 13. Furthermore, it extends some of the deadlines that were in the December 2020 Act that Ron just talked about. For example, the lease provisions. It extends a provision that was in that bill at the end of last year that says that individuals do not have to pay a security deposit to keep utilities from being turned off. That could be relevant because there is some case law that we'll be talking about later that says it is appropriate for individuals who are in business to be in a Chapter 11. So it extends a significant number of the deadlines. What it doesn't do that many of us hoped it would do, as Colette alluded to, is increase the debt limitation from the 7.5 to 10 million. Because as Colette mentioned, the 7.5 million covers about 50% of the Chapter 11s that are filed. If that debt limitation was increased to 10 million, my recollection is that number would go up to about 80%, possibly between 80 and 90%. So it's, you know, we're hoping that could still happen. It is not in this legislation, but we believe this legislation will pass to extend the $7.5 million debt limitation until, you know, at least for another year. So that's where we're at with the legislation to date.
And Rozanne, when they said we increased it to $7.5 million, we talked originally about, you know, them picking 2.7 million. It's not really like Congress picked 2.7 million. It was just a number that was already in the code that was just easier to go with. And so they couldn't move off the start. Finally, we got them off the start to 7.5 million. I can kind of go to 7.5. I'm not sure I'm on board with putting 80% of our caseload through this until it's tested more. But, you know, that's a point of discussion, you know. But anyway, I just want to clarify that the reason it's just this weird number that it reverts to isn't because anybody actually picked out of a hat 2.7 million. It's an old number that's been indexed to 2.7 with lots of digits after it with inflation that Congress sort of said, eh.
Let's
use that. Exactly.
Yep.
Well, let's talk about how the Subchapter 5 Act is going. Judge Opperman, thank you for being with us today. If you wouldn't mind, tell us a little bit about what you're seeing in terms of the Subchapter 5 caseload as it relates to normal Chapter 11s and whatever other initial thoughts you have on the Act so far.
Well, Josh, you're welcome, and thank you for inviting me, and thank to all of you for listening to us for the hour. I'm going to try to give you some information, and I'm going to start off with numbers because we'll get the worst part of the way out right away, and then we'll get into some more interesting things. Nationwide, our numbers are there's about 1,640 cases that have been filed in Subchapter 5 in the last year under the new law. So percentage-wise, that's about 23% of all of our Chapter 11s. And keep in mind, that's just from one shore to the other shore. Here in the Eastern District, the numbers are slightly different. We don't have a lot to work with in terms of absolute numbers, but we've had 17 Subchapter 5 cases filed in the last year, which constitutes about 40% of our total Chapter 11s in the district. For the calendar year 2021, that means the last 2 months essentially, it's more on a 50-50 basis. Again, these are small numbers we're dealing with. There's not a lot of numbers here, so I wouldn't want to draw too much from it, but I would draw the point that we are at least slightly, if not much higher than the national average. 23% versus 40 or 50% is significant. I want to now talk about the 17 or so cases that we have. Presently, 6 have been closed for various reasons. 11 are still pending. Of these 17 cases, as near as I can count, 6 have had an order confirming plan entered, and some of those have been closed completely. To Ron's point about the time that you need to decide whether to assume or reject a lease, the range of time to confirm these cases is a range from 4 months to approximately 8 months. So that is a very short period of time. We'll talk about it later in terms of a more traditional Chapter 11. But I think for the most part, you can honestly say that if a case is going to have a plan confirmed, it's probably going to happen pretty quickly. Likewise, if a case is going to crater, it's probably going to crater much faster too. And I don't want to draw too many inferences here, but of the ones that have been dismissed, one was voluntarily dismissed because the debtor wanted to get a PPP loan, and this was back when there was controversy as to whether bankruptcy debtors could have a PPP loan. So rather than fight that battle, the debtor decided to dismiss. The other one converted from 11 to 7, again, not unusual. The third one was filed by a pro se debtor. And if you just want to wrap your arms around that idea for a minute and say to yourself, how likely was that case ever going to go very far? And if you say more than, say, a week, then I want to talk to you about afterwards about buying some property like the Brooklyn Bridge or someplace like that, because pro ses in Chapter 11 just aren't likely to work. I want to talk next about, I think, an issue that's probably near and dear to virtually everyone's heart when it comes to any case, and that's fees. And I know this is a topic that a lot of people get a little nervous about, but we might as well just put it out on the table. We've had 5 cases where attorney fees, trustee fees, or accountant and financial advisor fees have been awarded. And I'm just going to go through them one by one. The one case had an attorney fee of about $18,000 awarded. The trustee fee was $5,500. Another case, about $7,000. The trustee fee was $9,600. Another case, a much more complicated case, $185,000 in attorney fees. The trustee fee was about $18,600. And then a case that I had the privilege of presiding over, the attorney fee was $396,000, and the trustee fee was $56,000, almost $57,000. Not to forget about accountants and financial advisors. Accountants were awarded $12,000 in one case, and a financial advisor in the one case was $185,000, was awarded $58,000. So, what to draw from all of this? One of the attractions of Subchapter V was that it was the elimination of the Unsecured Creditors Committee. And Professor Lubin, who has studied this, and I have not read his article recently, but he has kind of roughly said, and this is not etched in the code or the rules, the Unsecured Creditors Committee fee is usually about 50% of what the attorney fee is. So if you say, well, are we really substituting a Chapter 11 trustee for an Unsecured Creditors Committee? In all of these cases, the fees are much less for the trustee. So that's one way of looking at it. And the fees, I think, for the most part, it's very hard to draw a line here because some of these cases, 2 in particular, look to me like they're very complicated. And the others look more, to the extent there is ever a garden variety, Chapter 11, more along those lines. As I polled my fellow judges, no one seemed to feel that the fees were exorbitantly high or low for attorneys, and that the lack of the Unsecured Creditors Committee was a financial benefit, obviously, to the debtor. And if you believe in the trickle-down theory, it trickles down to the unsecured creditors as well. So that's kind of where we're seeing things here. I would make a couple of observations. For the most part, our judges find that the trustees are extremely helpful, that they help move the cases along. There's the idea of mediation, which I think is very true in Subchapter 5. And in the case I presided over, I think the trustee did an excellent job of mediating. The lack of a disclosure statement makes the plan easier to read. We don't have to read it, something that's not there. That could be an area for abuse, though. And the other is that what we've noticed, what we think, is that these cases get to where they're naturally going to go faster. Cases that are going to basically be dismissed get there faster. Cases that might succeed or have a better chance of succeeding are going to get there faster. And then finally, I took some time to compare the one case I had with another case that was a traditional Chapter 11 filed about the same time. And I thought, well, you know, it's very hard to compare cases, but this one might be worth it. They weren't in the same industry. They were not both impacted by COVID per se in the same way, but the traditional case was filed in January of 2020, plan confirmed in November of 2020 for a 10-month duration. The attorney fees are $227,000. Unsecured Creditors Committee was $120,000, which roughly fits into that 50% range. And it took me about 18 and a half hours to get to the finish line in terms of the order confirming plan. The other case that Rozanne will mention a couple minutes from now, Boyce Hydro, was filed last day of July of 2020. Plan was confirmed last week, February 25. That is 7 months. The attorney fees were $396,000 for the debtor. The trustee fee was $56,000, and I know there's going to be more fees on top of it. And it took me about 24 hours of court time. got to the finish line faster, but a whole lot more work to get there. And I think that's kind of what you're going to see in Subchapter 5. We can get there faster, but you better have an idea of what you want to do, because there's going to be time deadlines imposed upon you by the code, by the trustee, and by the court. So, Josh, that's kind of the broad overview that we're seeing in the Eastern District so far.
That's very interesting. I mean, especially your point about making sure you know what you're going to do before you file. I mean, I think that's a lesson to all practitioners across in a Chapter 11, even in the larger Chapter 11s, but especially the case here when you have such a tight time frame. So you were talking, Judge, about the Subchapter 5 trustee, and we have one of those in our presence here. But before I move to that, I just wanted to remind everyone watching that we will, if anyone has questions, we will have some time at the end, hopefully, to answer questions. So put your questions into the chat if you have any, and at the end we will look to see if there are, and we'll answer them as we can. So Colette, you are a Subchapter 5 in the Northern District of Ohio, Subchapter 5 trustee in the Northern District of Ohio. Tell us about how that's going, and what kind of role you feel like you play in these very new type of cases.
Thank you, Josh. I think in the Northern District of Ohio, our numbers are going to be very similar to what's going on in the Eastern District of Michigan. There's 4 trustees in the Northern District, and this district is from the Toledo area over to the Youngstown, Ohio area, and then down to Canton, Ohio. So it's a large district. There's 4 of us who are trustees, and we each have 3 or 4 cases. So there's somewhere in the range of say 15 to 20 cases that have been filed. A few have been dismissed. We have seen what I will call kind of the unworthy Subchapter 5 debtor, in that there's really not going to be a plan. There's just going to be a liquidation. And there's kind of an, I think and one of mine was that if that happened again, where I really didn't see a role for me to put together a plan because the debtor wasn't going to put together a plan, I think I would probably file a motion to discharge me because there really wasn't a role. And so I think we have to kind of look out for those. I do think the mediation function that we have is an important one. And I think it was taken from the experience of the federal mediation program. When we have cases in federal court now around here, I'm sure it's true up there, many of them, if not all of them, go before, a mediator. We have a mediation process, and a lot of times it's very successful at the early stages of the case. So that's kind of our role, is to bring people together to try and put together a consensual plan. And, in one of my cases, we meet, at least at the beginning of the case, once a week. What's going on? Is there anything I can do to be helpful? Where is this going? And we just kind of stay on top of it, because as you mentioned, the time deadlines are tight. If you're not prepared to meet them, I think you have to consider delaying the filing, because once they are filed, then the cases move pretty quickly. So that's our primary role. If there's fraud or some other bad acts, then the Subchapter 5 trustee can come in and operate the business and probably liquidate or sell it. I haven't seen that yet, but we've all seen it in ordinary Chapter 11s. And the code provides for that. There's an issue on whether or not the Subchapter 5 trustees do disbursements. Since, these are tight cases, financially, there's not a lot of money floating around. There seems to be consensus in the meetings that I've been to at the National Association of Bankruptcy Trustees that that's not a particularly great role for us, to be charging hourly to do disbursements. That unless there is bad acts going on, again, or some other compelling reason, if there are planned proceeds can be distributed by the debtors. And there's been a couple of cases where there have been non-consensual plans where the order confirming the plan says it's non-consensual, but we're still going to have the debtor make the disbursements so that the cost is not incurred. We were talking about the content of the plans, and I was just going to mention to the group that There's a plan on the New Jersey Bankruptcy Court website that's worth seeing. It's a form plan, it's a long plan, but we have used it in our office as just kind of a checklist when we're interviewing possible candidates, for Subchapter 5. And in an initial interview, it gets clients thinking about, well, what am I going to have to do? What is the plan going to provide on this subject? What might a consensual plan look like? So you can take it as just kind of an interview checklist, and you may find it as helpful as we have found it. I think, there's a note here in our outline about the types of cases. I mentioned the liquidating case. I have a case right now with a neurology practice. There were 15 neurologists. For one reason or another, the practice is now down to 5. And so there needs to be some adjustment of the debt. I think that was the type of case that maybe Congress might have been thinking about if they were thinking about cases. But I think it's a good candidate for a Chapter 11. And similarly, I have a dental case, a dentist case, some debt for a practice that didn't work out. That's being renegotiated and will be the subject of a plan. So those are, I think, very solid candidates for Subchapter 5, and we'll see what happens with them.
One quick question, if I may. You had mentioned that the debtors had, in some cases, or the debtors would be distributing plan proceeds when in a non-consensual situation. Anybody ever objecting to one of those one of those situations? Because if there's no objections, I can see people saying, "Well, okay, that's consensual," but the statute otherwise seems pretty clear. I the answer is I don't know, but I did look at this Park Avenue case, Park Avenue Leather Goods, and I think that was a non-consensual plan. And I don't know whether they agreed on that particular issue, of the debtor doing the disbursements, but that's what the order said. So that's something that I think probably the debtors would like to continue to do, is disperse their own money. So I turn it back to you, Josh.
Yeah, sure. Thank you for that insight. So, we have a question here from John Clem, which actually I think kind of transitions us into another discussion that we wanted to touch on is, who are the debtors? Have we seen true small business restructuring cases as Congress intended the act to do? And I know there's some case law out there and some opinions about, whether a debtor can use this as a means to liquidate, or whether they really need to be an operating business. Ron, you've looked into that. What are your thoughts?
I have, and to address the question as at least a little bit, when the problem that my wife used to have is she used to work in a hospital in anesthesia, and all she saw were sick people, so she concluded the entire world was sick. There are healthy people out there, but if that's all you see, that's what you think. And so far, I have yet to see a good Subchapter 5 case, so I have some severe doubts. I'm hopeful from hearing everybody else's experiences, but my case up here in Michigan was one where the debtor himself allowed it to be converted because he's going to be going to prison, federal prison, for various charges and whatnot. And I have another one in Florida that was not exactly a typical case, but I have hope. I have hope. But as far as the liquidation pit, that's an interesting question. It's an open question, and that brings in the judges, difficulties in trying to figure out how to implement this stuff, because this is all brand new to judges. It's only been around for a year, and they have to interpret it. And the question is, was the Small Business Restructuring Act intended to allow for liquidation? And if you look at what the definition is in the Bankruptcy Code has a definition for what a small business debtor is, and it says the small business debtor is a person a person engaged in commercial or business activities, and also with not less than 50% of the debt that which arose from commercial or business activities of the debtor. These are two different things in the definition, and so it seems to me when I read is person engaged means you're doing it. But the very first case to take a look at that was the Wright case, and I don't mean right in the sense of correct. I mean Wright in WRIGHT out of South Carolina. And, they looked at it and said, well, the debt kind of arose from business purposes. So they're dealing with their business purposes debt. Yeah, that's engaging in business activity. And to me, this is when you have the dangers of kind of letting what you want to have happen dictate what can have happen. Because I don't see how restructuring is engaging in business activity. If you're just basically restructuring and liquidating, to me, that's not commercial or business activity. But of course, once you have that opinion out there, then you have another opinion. These people, poor people out in Central District, California, had filed a regular Chapter 11 because they read it like we would, say, well, engaged means engaged. And then they saw the right case come along and said, please, oh judge, they get away with it. Cannot we get away with it? And the judge looked at it and said, well, yeah, what the hell? The door's open. So come on in. So the Bonet case comes along and says the same thing. And then Blanchard in Louisiana comes along and says the same thing. And so as I'm seeing this trend, I'm like, well, I can read as well as anybody else, but obviously I'm simply wrong because, that's how it goes. Until finally, recently in Louisiana, a judge who's now Missouri, a judge who's now my hero, Judge in the Nixon, I think is Norton, Judge Cynthia Norton in Western District, Missouri, said, wait a minute, engaged this is not a Clinton-esque moment of what do we define is to mean, and she went through all the times Congress said somebody is engaged in something, and it didn't mean, and she actually wrote, it doesn't mean the past, and it doesn't mean the future, or what we want to have happened. It means what you're presently doing, and if they're not presently doing it, then they're not engaged. And so if you think about it, that would, otherwise you'd read out one of the two big tests. You say you're supposed to be presently engaged and have your debts. If having your debts is all you need, then why even have the first part? So right now, the answer is, for those who are non-lawyers thinking about why do people make these intricate decisions over these little bit of words, the big question is whether or not the Small Business Restructuring Act, restructuring, does that mean restructuring and rehabilitation and going on? Or does that mean just simply liquidating? And, people have arguments for policies on both sides. My reading is that the better read is that at the moment, regardless of what policy we want, Congress said it's for rehabilitation and confirming a plan that goes on, not for liquidation, despite the fact that it might make an excellent tool for liquidation. But the answer is your mileage could vary because there's only 4 judges who have weighed in on it, at least in a published opinion. So that means there's lots and lots of other judges who will get that opportunity in the future to see which side of the fence they line up on. For me, I'm sticking with Judge Thurman if I can.
Why would a debtor want to use a Subchapter 5, excuse me, as a liquidation proceeding versus filing a 7 or doing something out of court?
Control, most likely. They get to put together the plan. They don't have to necessarily. I mean, in a liquidation, you have to give everything to creditors. In a Subchapter 5, you have to give projected income. And what if your projected income is essentially zero? Because you're not going to be reorganizing. There's no income. I give you nothing, but it's still liquidation because that's all I have to give. But I get to start right now. So I don't know. It's a tough call. I can see reasons why, mainly control and what kind of things you might do with it. But not a debtor's attorney. I do some debtor work, but not a small debtor's attorney. So I really can't say I have a great feeling for why people would do this. I do know one. And the one thing the guy tried to pull in Florida is because he wanted to file a 7. This is my Florida vein doctor who had $1 million income and he's fell on hard times and only made $300,000. And I know all the people on the panel and all the people on the call understand that it's really hard to make a living, going on only $300,000 a year. But he was tough and he persevered. But in most jurisdictions, even in Florida, there's this bit about bad faith. If you're making $300,000 a year, you sort of have to talk to creditors before you decide to just throw in the towel and file a Chapter 7. So I think they did it because they could file this thing and say, well, look, we tried. We offered everybody 1/4% of their debt, and they said no. So what else are we supposed to do? We have to liquidate. And the court bought it. So, could that, now it cost $35,000 to file a plan that meant nothing, just so he could get around that. But that might have been a great investment for him because, I mean, he's a vein doctor in Southeast Florida near the beach. He's got a year-long practice. He'll make it back.
Josh, the other reason that I could think of as a debtor's attorney is one, there's a much less likelihood that you're going to have a committee, so you have that expense. The other, which goes to the control that Ron was talking about, is if you wanted to, if there's a going concern that you're liquidating, you have the time and the luxury to try and market it and do that. And even if it's not a going concern, you know, you're not going to have a Chapter 7 trustee who may be selling things on a forced liquidation basis and at a much lower rate. So those are reasons I can think of that you might want to be in a sub 5 rather than a Chapter 7 as a debtor's attorney.
Okay.
And I'll give you one other example. There's a case here in the Northern District of a records maintenance company. They had paper and computer records there. They were closing, but they had regulatory issues relative to delivering back to their customers all of those records. So they needed time to do that. They didn't want a Chapter 7 trustee to do it. So that was a good option for them, although I think it was difficult for them to afford the whole process, even so.
I think it boils down to control. Is that if you have control, there are a lot of problems you can solve. You may not even be able to foresee them now, but so, suddenly something comes up where you can't, just a Chapter 7 just doesn't fit, and this would give you a way out. If it were allowed, as I would add.
Someone asked in the chat for a copy of the link. I will send that in the chat right now. This works. Let's see here. So, we had a very interesting case in the Eastern District recently that just confirmed last week, I believe, in Boyce Hydro. Judge Opperman was the judge on that case, and Rozanne played an integral role with her client on that case. So I think we'd be remiss if we didn't touch on that in the last few minutes that we have. Judge, Rozanne, I'll let you guys take the lead on this, but give us a little bit of background on that case, if you would, and explain some of the unique elements of it.
Sure, Rozanne, you want to go first? You want me to try to take a whack at it?
Doesn't matter, Judge. Feel free if you want to go ahead.
Well, to paraphrase some pleadings that I read time and time again, something along the lines of, on May 19, 2020, torrential rains hit the counties of Gladwin and Midland and caused the forced evacuation of over 10,000 people in the city of Midland alone. It goes downhill from there. But Boyce Hydro was essentially a case involving just a terrible natural disaster, if you look at it one hand, or a malfeasance on another hand. I don't know the answer, nor do I have to. But the case was filed very quickly after the rains hit and caused 2 dams in the area to breach and to flood better part of Midland. And there's a couple of interesting lessons to take right away from it. Number one, I don't think that Congress, when it was thinking about this statute, ever once thought about a case like this with all these potential claimants. But how Boyce Hydro became eligible, at least to me, was that it was before the claims were liquidated. And so you had millions of dollars that would be liability there. But the debtor's attorney basically filed early enough. And that's, one takeaway I always try to give to people when they talk about, should I file Chapter 11 or any chapter? It's usually, people usually wait too long. In this case, I think the debtor, if you're going to go into chapter anything, do it earlier versus later. Very interesting case in terms of the real issue at the end of the day. Involved, number one, who was going to control this property, to Ron's issue of who has control. And part of the answer was that I think virtually everyone informally agreed it shouldn't be the debtors anymore. And that the best candidate was Rozanne's client, who is an interesting creation under state law that was basically created to operate these dams going forward and to take ownership of them. And so you had a condemnation action. You had insurance issues because the debtor did have insurance, albeit very low compared to what the claims were. And then you just had a number of people who were very rightfully very, 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 very upset that their homes and businesses were flooded and destroyed in many cases, devastating for a lot of people. So the attorneys in each and every one of them, the attorney for the debtor, the United States trustee, the Chapter 11 trustee, all the creditors' attorneys, the bank's attorney, just did a fantastic job. And it was a pleasure presiding over it. I couldn't believe I spent 24 hours in court, basically hearing people talk, basically a day of my life, but it was well worth it. I think overall, not the greatest result for the creditors, but given where the case was, a pretty good result. Rozanne, I'm going to let you weigh in because you saw a lot more than I did. I'm just the judge, so go ahead.
No, not a problem, Judge. I will say that it seemed like a lot more than 24 hours of court time. It was a really intense case. I did represent 4 lakes. The counties had basically assigned through statute the right to file a condemnation action, and 4 lakes commenced the condemnation action, and it was immediately after that action was commenced that the bankruptcy was filed in July. But there were a couple of interesting things that came up in that case, a couple of interesting motions. One was that Judge Opperman had to hear was an issue of whether or not the case was properly in a sub 5 chapter 11. Now, the issue of whether or not the debtor was operating never was an issue, was never raised as an issue because this debtor was not operating. But the issue that was raised was whether or not they were over the debt limitation. And because the debt was contingent, very much like the Chapter 13 case law, Judge Opperman said they're eligible under that section. As I said, we never got to the question of whether or not the fact they weren't operating was appropriate, was a reason for them not to be in Chapter 11. The other matter that was raised, motion that was raised, was a motion to appoint a committee, primarily of the tort claimants. It was kind of an unusual motion. It wasn't a traditional motion, a committee motion, but Judge ultimately denied that motion as well, because there were many tort lawyers and bankruptcy lawyers associated with it that were litigating this. This is a case where the Chapter 11 trustee really did do a great job. He got involved when he needed to be. He stepped back when it was appropriate, and it was still expensive. There's no question. As Judge said, the attorney fees, I think through October, were close to $400,000 for the attorneys that were involved. And we haven't seen the fees for the time period through confirmation, which I assume will be at least that much. But it was a good result. Ultimately, there was a settlement with respect to the condemnation action that turned the properties over to 4 lakes. My client had been able to generate a number of grants, federal and state grants, to help do the property cleanup. And the issue in this case, one of the issues in this case was it had to be done fast. And that's one of the things that Judge Opperman really keyed on, because we had some severe and serious public safety issues. And if this hadn't been confirmed and the property hadn't been turned over, it could have been a more significant natural disaster. So that public safety issue, I think, pushed it a little more quickly. It was not what I believe was contemplated by Congress. Was it appropriate to be in a sub 5? Technically, yes, because it wasn't challenged from any other perspective, but I don't think this was what was contemplated. I don't know that being in a sub 5 really gave that much benefit to the debtor in this case. The absolute priority rule really never became a problem or an issue. And ultimately, it was pretty much a consensual plan, which if you had asked me at the beginning of the case, I would have said was virtually impossible because of some insurance issues and the like. But it was an interesting case. And again, I don't think it was one that Congress envisioned whenever they passed the Sub 5 Act.
That's very interesting to hear about that from the front lines, if you will. We have a question in here, and maybe we can end on that. We only have a few more minutes here, but are distributions based on projected or actual cash flow? Most written materials say projected, but not sure that makes sense. I don't know if Colette, or I don't want to put you on the spot, or Ron, or Rozanne have any thoughts on that?
I have not had to face that issue yet, but I don't think I would ever do projected distributions if I wasn't sure I had the money. I think it would just be what you be making distributions on what you have in the bank.
Well,
Yeah.
the plan, the language of the SBRA says you have to provide all of your projected distributions for the next 3 to 5 years, and that the court has to find that you're able to make them. Now, I suspect that if you simply say, I'm going to turn over all of my all that stuff I get, then the court would say, well, I find that you can turn over everything that you will actually have. I mean, that's probably a low enough bar. The question is who monitors at that point to make sure that that indeed truly is the correct amount of projected income, because, it's projected disposable income, and disposable income has a few things. And one of the things you can deduct from it is necessary operating costs. But how much of that is going to go into investment? I mean, if you don't invest in a business at all over 3 to 5 years, you're not going to have a business. But at the same time, do creditors, are they the ones who have to bear the cost of you trying to double the business? So I think it's too soon to say how this is going to play out. This is the kind of thing for objections yet to come, but the phrasing in the statute says projected disposable income. So for the moment, that's what we have to work with, I think.
I think your comment, too soon to tell, or however you just said it, I think is a theme that we're all kind of working through. The statute's very young; it's only a year old. Most bankruptcy practitioners are well versed in how a traditional 11 works, or how a 13 or a 7 works. So we're all kind of learning on the fly, and it sounds like, I won't speak for Judge Opperman, but the judiciary is also kind of learning on the fly, and that's why you see some case law out there that is opposite of each other. And I know Rozanne has to run for another subchapter 5 right now. So I don't know if you have a couple of thoughts on the Columbus oil case that you're working on, and then we'll say goodbye.
I actually am in the middle of an evidentiary hearing on the motion to convert, so I do need to run. But again, not your typical sub 5 case. It's not an operating case. The basis of the case is some very significant state court and now federal court litigation with respect to the validity of oil leases. It's not your typical sub 5 case. None of the sub 5 cases I have been involved in, I think, fit the framework of what was contemplated. In this case, the motion to convert is based on inability to rehabilitate and file a feasible plan, based on the fact that they haven't operated and they're projecting pretty significant oil development and returns in a very short period of time. But stay tuned on that one. The motion to dismiss is still being litigated as we speak. So,
well, thank you. If anyone wants some insight on that case, they can reach out to Rozanne.
Absolutely.
Personally. As with all of us, feel free. Unless anyone on the panel has any, parting thoughts, I'd just like to say thank you all for joining us, and thanks to the panel for their insight and all of your hard work preparing for this. And maybe we'll have another one, SBRA 2 years later, next spring.
I was thinking that see you next year might be the way to end this.
Right, yeah.
Thanks, everybody.
Thank you, everybody.
Thank you.
Thank you. Bye-bye. Bye.
Goodbye.